Well, good afternoon, everybody. My name is Tom Dunn, and I am the Director of Business Solutions at TCIA. We want to thank you all for joining us for the first in a series of webinars TCIA will be hosting on important issues for your business related to the coronavirus. We hope to have at least 2 more on different topics over the next 2 Wednesdays at the same time. So I encourage you all to check for updates on tcia.org, but we'll also be sending out information on these as well. Today's webinar will provide an update on the latest information available on the Families First Coronavirus Relief Act's paid leave, sick leave, and expanded FMLA leave with a focus on how it affects tree care businesses, including the available guidance that is current on employers' options on seeking an exemption to these new obligations. I'm pleased to introduce our presenter today is Attorney Matt Neiman, who is a principal and office litigation manager at the Jackson Lewis Law Firm in Washington, D.C. Serving as panelists today are Kristy Hiller, who is the Human Resources Director at the Tree Care Industry Association, and Aidan O'Brien, who is the Advocacy and Standards Manager at TCIA. Just a couple of housekeeping items. We have a high number of participants today, which is great. So we're going to keep everybody muted except for the panelists to try to keep the background noise to a minimum. You will have the ability to ask questions by clicking on the Q&A button and typing them in, and we'll try to address those after the initial presentation. Other attendees will be able to see your questions and vote on them, so that will give us an idea of the most popular questions that we can try to answer for you. Our goal is to get as much information out as possible. So if you could focus your questions on the broader topics and not specific questions to your company. So with that, I'll turn it over to Aidan and we'll start the presentation.
All right, thanks, Tom. Hi, everyone. This is Aidan O'Brien. As Tom said, I'm TCIA's Advocacy and Standards Manager. And so as my title suggests, I'm in charge of advocating on behalf of TCI members on the federal level mostly, but these days with the coronavirus situation ongoing, I've been doing a lot of work on the state level, sort of on a broad level, trying to get the most up-to-date information out to all of our members. And so that's been working on the essential services designation and just the most up-to-date information on all the federal and state programs that are ongoing. So Matt's going to touch on those in detail today. But if you have any questions in the future on what TCI is doing to advocate on your behalf, please direct them to me and happy to talk to you a little bit more. So I'll turn it over to Kristy now, who can introduce herself.
Thank you so much, Aidan. Good morning, team. I'm Kristy Hiller, the Director of Human Resources here at TCIA. I just want to take a moment to acknowledge that it is very natural for us to have and be experiencing the elevated stress levels since all of this is going in real time. This is definitely a new territory for all of us. And so today you'll find that we are presenting what we know today to provide you all with general guidance. There continues to be various updates daily and clarifications on the regulations from the Department of Labor and other various sources. And I also want to take this opportunity to remind you to please check our TCIA website. On the TCIA website, you will find a link for COVID-19 that does have FAQs for our members, inclusive of model policies, and also some direct links to the Department of Labor for what is almost being updated daily with our questions and answers page. So we want to thank you for joining us this morning. And also please know that some of our answers, may be dependent upon the governing body and other various sources, and just to walk away today and feel confident about some of the general direction framework that we're going to provide you. And without further ado, I'd like to introduce Matt for our presentation.
Good afternoon, everybody. I promise I see the one question posed. You will not be looking at my smiling face much longer. We've got a PowerPoint presentation that's going to walk us through what we're talking about here. As we go through, I'll be sort of taking the lead on the questions as they come, and then Kristy will be chiming in as we go through. And lest you try and channel some carpal tunnel by making notes furiously as you go through, we'll happily make the slides available to you in a PDF afterwards so you can refer to it in that content. My slides go forward here. my smiling mug. Text notices all over the place, so I know there's many of us joining earlier in the morning. We're at 61 locations all across the country, so we are feeling this as much as you are potentially feeling this. But there are a number of questions that keep coming up all the time. Largely, this has to do with the sort of moving target that COVID-19 and the coronavirus are. And as a first notion is sort of what should you be telling your employees altogether? Because many of the concepts that we're already talking about are employee relations ones. I mean, what can I do? What should I do? What is my concern? And part of that is just making sure that you make sure your employees know that you're actually paying attention to it, and make it clear to them that you don't want anyone coming to work ill, in part because you're trying to make sure everyone stays as healthy as possible. We're not trying to have this be perpetuated by any of our actions either. Amazingly, a month ago, we were talking about this as being something fully overseas and what we would do if it comes here. And now it's a question of, you know, what used to be, did you just travel here from China, is now, did you just travel here from New Jersey? Go figure. All of the sorts of things that you would have in terms of asking people to perform environmental cleaning, make sure they're using gloves. I mean, the things that you would normally think of in your business to prevent them from getting, you know, grazed by trees, whatever else, could also apply just wearing gloves in this context as well. But making sure that people are doing the things as possible to, you know, wash surfaces people routinely touching, whether that's steering wheels of trucks or things of that nature. This is a seriously moving target, and where there are community outbreaks is changing all the time. Talking to folks all over the country, and you never know where it is. There's certainly hotter spots than others, but be aware of the situations in your local community. There's a lot of focus on sort of national statistics and broad stroke things, but look in terms of what you are able to do. I'm sure many of you have already been making these determinations as to sort of what the business will bear and won't bear, whether there's ability to have any remote work. And when I say that, I'm not necessarily referring to the folks who are in the field, because that's in the field, but if you've got folks who are office personnel or things who would be handling, you know, dispatch calls, is that something that can be done remotely versus not? And I'm not presupposing what the answer to that question is. I'm more saying it in terms of you want to be thinking them through so that if things are happening, what can you do about it? And the last bullet, which I'll just make a reference to, is to the extent that you have, you know, contracts which you're expected to be doing a bunch of work, but the circumstances are preventing you, whether it's because your workers are out or because there are stay-at-home orders which you are not exempted from, make sure you're looking at your contractual agreements, whatever contracts you have with people, to see if the facts and circumstances that we're talking about could implicate the force majeure clauses that are in there. Oftentimes they refer to acts of God or storms. Well, this would be a pandemic. And when I say that, it's not necessarily a sink or swim concept, meaning the contract is either broken or it's not, but it could go towards things like if we had an expectation of this, you know, work being completed by April the 15th, you may be able to use those provisions to talk about getting it done by May the 1st or some other time, which allows you to better plan around it without having to send work away or losing it altogether. A common question is what happens if I've got a family member at home with confirmed COVID-19? That's when you should refer to your CDC's risk assessment for whatever that is. On a certain level, it matters what that person does or doesn't do. But generally speaking, if you've got someone who has direct contact, you're going to want to have them stay out of work for about 14 days. That way you're not having the transmission go to someone else. We'll allude to it at least briefly later, but when you're talking about things like workers' compensation or whether things are OSHA recordable or reportable, a lot of that has to do with whether it's something that you've got at work. And if you know someone has a higher likelihood of having been exposed to the virus and you keep them in the workplace, that could increase the chances of having the COVID-19 virus be attributable to you in a workers' comp or an OSHA type level. Same thing applies when you find out in other fashions. I mean, I'll tell you 2-3 weeks ago, the primary questions I was getting is, hey, we just found out that so-and-so was talking to so-and-so who's in a building where they found out this was happening. Well, obviously, the closer the contact gets, the more important it is to be determining whether the risk can be managed or not. And just be aware that it changes all the time. And when you look at those sorts of things, it's almost always going to be a better idea to limit your risk in terms of making sure people are not around where there's direct exposure. But if we're talking about what my grandmother would call shirt tail exposure, like I know somebody who knows somebody, just be using active risk assessment, meaning not just everything's a no-go, and instead be focusing on it in terms of, what is my local guidance? Is the health department giving me anything like that? If you have an employee who tests positive or has the symptoms, you definitely want to be communicating with your state and local health department as to what their guidance is. And that guidance is varying tremendously across the country based upon what you're in. And I've got some clients who are totally locked down, nobody can work, and other places where the local health department's like, we're good, just wash your hands. That's a pretty big variance one way or the other. And realize that your communications regarding it are as important on some level as to your actions. Do maintain confidentiality. Don't say, Joe's wife's got COVID-19. You say, we've learned that there's an employee who has this. This is the actions that we're taking, because you still do have certain confidentiality and privacy-related obligations, which we'll talk about a little bit more later as well. Now, this is the $250,000 question, or however we're going to phrase it, and we're going to talk about this more. You should be tracking your local laws in terms of whether there is any local things. So, for example, New York State has some aspects of paid leave which are above and beyond anything at the federal level, which we're going to be focusing on here in a moment. But to the extent any of you have unions, you should look to the collective bargaining agreement, be looking around, and we're going to talk here extensively about what the federal law entails. So, when the Family First Coronavirus Response Act was passed, the two primary pieces that impacted you were enhancements to both the Family and Medical Leave Act, as well as the extension of paid sick leave. Now, we're going to start with the FMLA portion, in part because it's such a dramatic change. I don't know exactly everyone who's on the call, but in normal times, FMLA only applies to those with 50 or more employees and not 50 or fewer at any level. But when the Corona Response Law was passed, they, for reasons not entirely clear to me or anyone else, chose 500 employees and fewer without a floor as the baseline for who is subject to providing these new things. There are some carve-outs that deal with healthcare providers and emergency responders, which I don't believe would apply to any of you. But then they left in this provision, which you'll see there on the third bullet, that seemed to talk about whether you could be exempted based upon the viability of business as a going concern. That's all that it says, but it's important to understand what that actually applies to. When we're talking about a potential exemption, we are not talking about an exemption from all of the sick leave or from all of the FMLA leave. Instead, what we're talking about is an exemption from paying an employee who largely has to be out of work to care for their child, 18 or older, because the schools are closed. Now, I'm speaking to you from Virginia, and in Virginia, the governor has already indicated that schools are not only closed now, but they do not intend to have them return to school for the remainder of the academic year. And for that matter, we have a stay-in-place order that's somehow extended until June the 10th, which is a long time. But when we're talking about this exemption, we're not talking about you being able to opt out of paying the sick leave if someone was actually ill or caring for someone specifically who was receiving treatment for COVID-19 infection or otherwise. But we're talking about the portion dealing with 2/3 pay, which we'll talk about in a second, per day to care for their kids because their daycare is closed, the school is closed, or otherwise. While the law itself only refers to the idea the Department of Labor can issue regulations. There are no regulations as of yet. Instead, the Department of Labor has issued a series of, just say augmented, because they keep making it longer rather than issuing new ones, questions and answers. And they're up to 59 of them now. And 58 and 59 of the most recent version includes the factors that you see here on the page, dealing with whether or not a small business, i.e. one with 50 or fewer employees, can claim an exemption from paying that child care version of the family and medical leave, and the same things apply to the paid sick leave. And they come in groups. So the first one, as you'll see on the page, is just in general. Like, I can't afford to have to pay this because in doing so, it would cause my business to cease operating at minimal capacity. 2 is a variation on that, which is I can't have this person or these particular employees go because they have such specialized skills or knowledge or responsibilities that if they were out, even if other people could work, functionally I'd be stuck. So think of your foreman or whoever else it might be that would be so critical that you just don't have someone to fill that void. And then the third one, which is a similar variation on that same theme, is not that any one person has the specialized skills that you can't do without them, but the number of people that want to take it would make you unable to operate. And when I say that, let's say you had 10 people who were qualified tree climbers. I'm just making this up as I go along. And 6 of them were going to take the leave. And there's no way that you could perform the work with the other 4. You would be able to claim an exemption by way of saying, look, if the 6 people are out, I can't perform at a minimal level with the 4, and therefore that is my exemption. Now, a great question that goes along with this is, okay, I think that applies to me. Well, who do I tell? And the answer is, we don't know yet. One of the question and answers put out by the Department of Labor says, please don't send us this information now. So the best direction that I can give you is to maintain the documentation that you would have showing how this would be impacting your financial abilities, and keep it until they let us know where it needs to be sent. For what it's worth, and we'll talk about it briefly later, some of the payroll protection and other SBA loans that are available will likely entail similar paperwork, so you can actually be doing 2 things at the same time. But these are the best knowledge we have of the factors that the Department of Labor, at least we understand, will be the one ultimately determining if an exemption is appropriate or not. So as I mentioned a second ago, and I kind of pushed that exemption portion to the beginning because I knew it was important to everybody here, here are the normal requirements on the lower level as to what would normally qualify for some FMLA. So even those of you who are on this call who have 75 employees, you may not normally have to deal with it because you've got, someone hasn't been there for a full year. Under the FMLA expansion here, as long as someone has been employed for you for at least 30 calendar days, they're eligible to take the leave. And that includes if they are hired now, 30 calendar days from now, they would also be eligible. So keep in mind that the rules have just been fundamentally changed in terms of eligibility. Now, in order to be able to take this leave, the biggest trigger is that they are unable to work, including telework. And I made a reference to this before, but it's worthwhile of repeating. Not all of your workers are in the same spot. And when I say that, if you have somebody who is, a dispatcher or works in your accounts receivable in the office, they may very well be able to perform some of that teleworking. And if they are able to telework, then that is not an eligibility for getting the FMLA. The one thing to realize, though, is that in terms of the public health emergency, as various states and even localities are issuing their own closure orders, you want to be able to be clear as to what is covered and not covered to see whether or not you fall under the first factor, which is the person is subject to a health or otherwise isolation order from a state. This is what the FMLA portion covers. For those of you who've been involved in FMLA before, this is a variation of what you knew. For those of you, this is bold new ground. Family and medical leave in general is 12 weeks. So for those of you who already had employees who were able to take advantage of family and medical leave, this is just another way to use that same leave. So if you had someone, for example, that took off 6 weeks in January of this year for recovery from a surgery, they would only have 6 weeks left of FMLA. The way that the FMLA for COVID-19 works, the first 10 days are unpaid, just like normal FMLA. And then for the final 10 weeks, assuming they had all 12 when they started, are paid at 2/3 of the employee's regular rate of pay. There is a cap of a $200 a day payment and $10,000 in the aggregate. When we get to the paid sick leave, we can talk in terms of how that is different. I will tell you that one challenge that many clients that I'm working with are facing is they have people that perhaps make more than that in a day, and what do they want to do with the balance? And that's more of an employee relations issue as opposed to a legal requirement. The law is making you do the 2/3 pay for the duration with a cap of $200, but that's obviously not going to impact all the people in the same way. Along with this is the idea of whether or not employees can use the family and medical leave in less than full day increments. You may know that as intermittent leave in other contexts. It's not clear from the Act. It just sort of leaves it silent. The fact that they have taken these provisions and stuck them into the already existing family and medical leave law says that it seems like they could. And the Department of Labor, insofar as their question and answers, have said, well, if the employer agrees, then it can happen. And when I say this, my example from a moment ago about the back office person who is doing accounting, maybe they can telework, but it's only 3 hours a day. I think there's a pretty strong argument that they would be able to work for 3 hours, but they would be eligible to take this leave for the other 5 hours in the day. But that is, on some level, an educated guess right now because the regulations are not yet issued. There are notice requirements that relate to this. On the slide is actually the link to jump to the poster that has been put out by the federal government, Department of Labor, to put up on your wall. Things are moving so quickly that, in fact, when they originally posted this last week, there was an error on it, and they had to immediately reissue it. So if you printed it out the first day, I would suggest you go back and double-check that you have the most current version that is there. Just as you have notice requirements to put the poster up, employers are supposed to give you as much notice as they can of knowing it's coming up. I found that in the context of the coronavirus, people have been talking more about these things than less. So that the idea of somebody sitting on it seems less likely. But then again, every day I hear other stories. There's one, was it yesterday, from the guy who lied about his ongoing coronavirus symptoms so that he could go with his wife to the hospital for her to give birth, and only admitted that he'd been hiding it when his wife tested positive, thereby having already exposed everyone in the maternity ward. So be vigilant and hope your people are going to be in it, but be active about seeing whether or not people are showing symptoms or otherwise, especially now with these leave laws in effect. They're not going to potentially suffer the same financial consequences that they would have beforehand because this safety net is now in place. In fact, today is the first day that the law took effect. Last bit, which I will just mention, is under the Family and Medical Leave Act, in broad strokes, you have the entitlement to come back to your same job when the need for the leave is over. I will note that there is explicitly built into the law an idea of there being an exception to this job protection rule, which, unlike the exemption for providing the child care leave kicked in at 50, this one's for employers with 25 or fewer, where if based upon changes in the economy, that job just doesn't exist anymore, there are a different set of metrics that are available in terms of whether they're entitled to their job back and what you need to do. At this point, the situation is ongoing, so there's less to do here, but just be aware. Now, in tandem with the Family and Medical Leave that we were talking about is the Emergency Paid Sick Leave Act, and it applies for the same group of people, and it applies to all the people that you've got. So anybody who's employing folks with 500 or fewer is covered by this law. What it provides is 80 hours of paid sick leave for full-time employees. And if you've got people who don't work 80 hours, they basically get the amount that they would be normally working. So that's part-time or they work extra time. And when you're in that context, they're entitled to essentially be off for 2 weeks. So the way that it's actually driven out, if you actually have people who regularly work 45 or 50 hours a week, they would get that. So they're getting the time off for the 2 weeks, but there are still also caps on what they are able to be paid, at least under the law. But very importantly, and that's the reason why it's bolded on my slide, this is in addition to any PTO or sick leave that you may already be providing. So it's and, not, hey, I've already provided this, do I need to provide more? If the question is, do I need to provide more? The answer is yes, you are required to provide this unless we talk about the exemptions and the child care aspect. These, and the same things apply for the FMLA, are the 6 reasons why COVID-19 related leave is available. So I made a reference earlier to pay attention to what your local stay-at-home or quarantine or isolation orders are. That's number 1. And then the ones for 2 and 3 are the direct to the employee, like, hey, here's, I think you need to stay home for a self-quarantine, you're showing symptoms, maybe you've not been tested yet. 3 is they're actually experiencing the symptoms, and part of this is they think they're, sick, they're not sure, but they haven't been able to see a doctor yet. This leave covers them seeking a medical diagnosis. And there's an important part to track here, and it's a benefits related question, and your individualized benefits more than I would. But telemedicine is something that is being heavily encouraged in this context. And when I say telemedicine, I'm talking about people working through the internet or a phone call with a physician they're not actually coming in to see individually. Obviously, we're trying to keep beds and otherwise open in hospitals so that the buses are available for those who are actually infected. But that also means that if we're not sure if somebody has COVID-19, they're experiencing the symptoms, and they use the telemedicine, which is likely to be something covered by your benefits to the extent you offer them, then it's entirely possible that they are still seeking a diagnosis which isn't ruling out COVID-19, but nor are they being directed to be tested. It's sort of a wait and see approach. That would likely be covered by number 3. So realize that you could have somebody who's getting the leave who has the symptoms but may not actually be fully diagnosed for it at the same time. 4 is the variant on that, where it's caring for their spouse, child, whoever else who is being cared for, which is a classic FMLA notion, except here the difference would be if they were using it as on number 4, that would become eligible for a paid status if they're caring for somebody else, whereas normally you'd just be using your own sick time. 5 is the caring for your kids if the daycare has been closed. It talks about schools, but daycare and child care providers are the things involved. Many of you are probably having these challenges with your employees already and trying to figure out what is or isn't happening. And 6 is the catch-all, where there may be other things that are out there which are similar. And realize that all of this is premised upon running through the end of the year. So even though we're talking about 2 weeks, they could potentially use it anytime between now and the end of December. Here are the caps. You know your people and how much they're paid more than I will. But when we look at what we are talking about, if we're talking about so you can take care of your family, like childcare, the school's closed, it's going to be capped at $200 per day. But if we're talking about people caring for themselves, they're showing the symptoms, they're under the individual quarantine, whatever it may be, that actually is a cap of $511 per day. So each of these caps and numbers are per day and per the 2 weeks that we're talking about. So when we look at this, one of the things that you have to be able to determine in looking at it is if your people make more than $200 a day and they say, well, I got to be out, are you going to make up the difference? You have to decide what you want to do. There is no obligation under the statute to pay it, but in terms of making people whole, that's entirely something that is likely to be coming from them, and you need to decide financially, however you want to do it, and this actually applies in the same fashion to whether you might apply for one of those payroll protection loans, just in terms of understanding what you can afford to do and what you want to be able to communicate to. Again, just like with FMLA, it is not clear as to whether someone could take less than a full day, meaning could they take intermittent use of this paid sick leave time. The reality is the Act seems to say you cannot, but given that one of the qualifiers is that you are unable to work, including telework, going back to my example about the back office person who may have 3 hours of work they could do a day via telework, it would seem to me that they could take the 5 hours, but we don't have regulations on that, so on a certain level, think it through. Similar as for FMLA, and frankly they're triggered by the very same things, you can have somebody follow your notice procedures. And when I say notice procedures, someone can't just not call you. So the idea being no call, no show isn't acceptable. So if they're out sick, they still have to call you, and you can even have them call each day to make sure things are going along. And the same poster from the Department of Labor applies for both the paid family leave and the paid sick leave. When the law first came out, folks thought it was going to take effect tomorrow. The Q&A indicated it would be taking effect today, so happy April. These things are now in place, and they will run through the end of the year. Hugely important in this is the idea of tax relief for you as part of being involved in providing these leaves. The way that the government is, I will say, paying for or trying to assist employers in providing these brand new benefits is by allowing for a credit, a dollar for dollar offset from employment taxes as it relates to the benefits that are being paid. And as you'll note here in the slide, you not only don't have to pay them, but it's also possible if you don't have sufficient payroll taxes to cover the cost of whatever it is that you're paying out, you can actually request an accelerated payment, i.e. getting paid back to you from the IRS, essentially borrowing against your future payroll taxes in order to cover the ability to pay these benefits. On Friday of last week, you've probably heard of it talked about as a $2 trillion stimulus package, and we're just going to kind of blow through some of these so we can get back to your questions. $350 billion of the CARES Act was focused at small businesses. As with many things that they try and rush to get accomplished, there are some errors and there's some confusion and things like that. But the three ones, which I'll just highlight for you, and I suspect many of you have already began to investigate, is that there is the Payroll Check Protection Program, which is loans which you can get for up to 2.5 times the business's average monthly payroll costs. And on top of that, and I see a typo there, it's loan, not load, you can potentially have that loan forgiven to the extent that includes any of those things that are mentioned, including your utility costs, rent that you've had to pay, even mortgage obligation interest during the time frame. So there are some serious strings attached to that, including potentially neutrality if someone wanted to try and organize your workers. It's a pretty darn generous program, especially with the forgiveness. There's also, and this may have already applied for you or not, the availability for a $10,000 emergency grant, which is payable within 3 days for emergency economic injury. It's the same procedure as the SBA economic injury disaster loans, but there are some limited purposes. We're not going to go super deep into it, but it's $10,000, which is payable within 3 days. So if you're finding yourself in a harrowing financial spot, that might be a position to get some working capital. And finally, and this overlays with even some of the questions I've seen popping in the background, there is a huge impact made by the federal government on unemployment compensation. And when you are thinking through questions in terms of how to do right by your workers, in terms of what can you pay for them, should you furlough them, whatnot, the federal government is pumping an astonishing amount of money into unemployment. And part of that is by fully funding the first week, so there isn't even a waiting period, assuming the state abides by and adopts the same rules. For that first week, normally with unemployment, there's a week wait. It also extends unemployment insurance by 13 weeks and makes it that people can get 39 weeks of unemployment. And further, and this is pretty darn dramatic from my perspective, they're entitled to a $600 weekly benefit on top of whatever the state or local unemployment compensation would be. So that's a heck of a lot of money, and there's other impacts in terms of whether or not people have to be going out to try and find jobs. There's a lot of things there, and that's a lot of money. So it's something to be aware of when you are reflecting on, do I have the people at 2/3, or does it make some sense for people to be collecting unemployment even if you're furloughing them? This is a safety net that's extraordinary in my experience to allow for other things to be caught up on. Last bit, and we'll just cover this briefly and leave ourselves about 20 minutes to answer your questions as they come through. Just sort of other attendant issues. I mentioned briefly before the idea of workers' compensation and OSHA reportability. Workers' comp obviously doesn't apply unless we're talking about things that are work-related. How one establishes whether someone was contracting COVID-19 from work is a whole lot of a question to be answered. And the same notion applies to sort of the OSHA idea of a general duty of providing a safe working environment. I mean, obviously PPE is something you'd be providing, but at the same token, PPE for not getting your finger cut off is not necessarily the same thing as PPE for avoiding someone coughing or otherwise, so it's different things to be concerned on. I will note, just as an aside on this, I'm not going to go into any more detail on the OSHA piece, except to note that Jackson Lewis, in part of our sort of corona response team, is having a daily briefing on some of these topics, and my partner, Tressie Cordero, who's the head of our nationwide OSHA practice, is actually giving a presentation tomorrow on the OSHA overlays and implications. So if that's of interest to you, just head to the Jackson Lewis website. You can sign up for it and get that piece with a deeper dive. On the privacy front, though I hear people referencing HIPAA all the time, I am almost positive that none of you are doctors' offices. But you still do have obligations to not, violate people's privacy or otherwise violate confidentiality obligations. So as I referenced before, if somebody comes to you and says that they've got COVID-19, you would obviously be sending them home, potentially getting them paid sick leave or family and medical leave. But when communicating that to your workforce, you don't say their name. I mean, you take the steps that you can, but you can convey information to people without exactly saying who it is. And every time something comes up, you're taking your risk assessment, but you got to remember part and parcel of your risk assessment is also making sure that you are doing the things that maintain or limit the risk while still maintaining people's privacy and confidentiality. On the wage and hour front, remember that if you've got somebody who is exempt, they are entitled to their whole paycheck for the whole week, even if you only have them work part of it. If they don't work at all, so let's say you furlough them and they don't work at all during an entire week, then there's no entitlement to pay. But the moment that somebody who is exempt works an hour, they're entitled to be paid for that entire week unless you actually discharge them. So be careful on that. You can reduce exempt employees' salaries as long as you're not dipping below the rate that would make them not exempt anymore, which is roughly the $35,000 a year line. And on the flip side, if we're talking about folks who are not exempt, those who work hourly, especially if we're talking about that back office person who might be working remotely, making sure that they are adequately and accurately recording their hours is something that is critical. Last couple items here, and then we'll switch over to your questions. If you are going to be doing furloughs or layoffs, be aware of implications under the WARN Act, or when I say mini WARN, I'm talking about whether there's one for your state or even your local city, which may apply at smaller levels. Generally speaking, we're talking about shutdowns that would be 6 months or longer, so be aware of that. When we're talking about health insurance and COBRA, if somebody is out on family and medical leave, they're actually entitled to maintain their benefits while they're out. But if you are discharging people or you are furloughing them in some fashion that it triggers something in your benefit documents, do make sure to get out those COBRA notices, or if you're small enough, the state level COBRA notices, mini COBRA, to let people know of their rights to claim benefits. On the immigration and E-Verify front, there are still rules to be pushing through, and you still do need to use E-Verify within the 3 days. There are other pieces in terms of time variances and things of that nature we can work through. We're not going to dive into it here. Just be aware of it. And then finally, just remember what your own policies are. For better or for worse, we write up our PTO and leaves of absence and whatever policies, not expecting to have a pandemic or some other emergency. But when those things do happen, your policies are also functionally promises made to your employees. So if you have a policy in your handbook somehow that says you're going to pay people severance if you ever furlough them or something like that, then you want to follow that policy. If you give somebody severance, you're entitled to have them ask for release, but just remember to think all those items through. Finally, and these are just sort of practical problems, then we can switch right over onto your questions. Don't let people who test positive hang around. And if you have people who believe they've been exposed, I mean, there are people who believe they are more susceptible than others, I'll phrase it that way. Use the risk matrix. The CDC provides a pretty good recent, and they update it as things go along in terms of what the risk maintenance are, to be able to say what it is. Winging it will never work, and plus not having a framework to discuss the questions in puts you in a spot which is a whole lot more difficult. So use these priorities and think of it in terms of, what's the threat to your workplace? Under the American Disabilities Act, you are able to address direct threats to your workplace. And here, somebody who believes but isn't yet sure if they've got COVID-19 is certainly something you want to address as a risk assessment, even if it's not something you had to deal with before. Trying to be positive, do the best you can to be social distancing and cleaning house, but realize this is a scary time. And communication, even if imperfect, is better than being silent. And the more sort of proactive you appear to your employees, the better off you are to be able to handle these issues as they go through. That's it for the slides. There are a number of questions that have been coming in. Kristy, you want to chime in?
Thank you so much, Matt. I really appreciate that. Again, as a reminder, this will be PDF and being able to be shared with our website. I cannot stress our website, the TCIA website, enough, because as a clarification comes through with the various governing bodies, we will be posting that up on our websites. And there are, again, current model policies up there for resources as well, too. I know we have a handful of questions that have come in, which are great. So Tom or Aiden, I don't know if you want to punt us the questions.
Yeah, Aiden, why don't you go ahead and pick some of these to get it started?
Yeah, sure. So one that just came up was, if you can work from home, can you still qualify to use FMLA if you are caring for your child whose daycare is closed?
So the answer is, to the extent that you are unable to work, yes. But if you're able to work, then no. Which, if I go to it, that intermittent idea, it may very well be, for example, that someone and their spouse are both each now working from home, but they can only focus on their work for 4 hours a day. So if you are able to work, you're not eligible during that time, but to the extent that you are not, you can, which is where the intermittent part comes in.
And just to piggyback what Matt has to say, communication and documentation is really key in the instance of intermittent leave. So I know I've seen a few examples out there that, I do need to care for my child due to lack of daycare in school for 3 hours, but I can also work a 5-hour shift. And so as the employer and the employee is navigating that conversation, it's very important that it's transparent and expectations are managed, and better yet, even put in documentation as well too, so that the employee knows what they're being held accountable for. And then as it relates for the processing of the time off, that's very clear as well.
So we just got another question, kind of a follow-up on FMLA. So if there are employees out for an extended period of time that qualify for FMLA, do we just put in fake hours into our payroll and pay them appropriately, or do we go through some kind of different avenue so that the hours are categorized as FMLA?
I'm never going to use fake hours in my lawyer capacity. Say is leave. So however you would code someone if they were taking PTO or sick leave or otherwise, you would annotate it as that. Insofar as the documentation goes, regular FMLA has a certification form. It's not explicitly been said in the law or in the non-existent regulations that to do it, but I would encourage you to at least have an email or otherwise the person confirming that they are on the FMLA, and then you just, track it. To the extent that you are putting it on a payroll stub or otherwise, you can work with your payroll company, or if you're doing it yourself, to indicate that these are the hours and they're being paid in this fashion, so that it's, if it would normally say, PTO taken, it would say FMLA taken, especially if you're talking about the 2/3 pay hours.
That is correct. Here at TCIA, we just had our first staff member step out last week to take advantage of this. And working with my payroll company, we came up with a new code of leave, which will allow me to be able to track my hours, apply for potential credit in the future as well.
So we just have another point of clarification here. Do the same potential exemptions to FFCRA for employers with fewer than 50 employees also apply to the Emergency Paid Sick Leave Act, or is that act mandatory for all employers, no matter how small?
It applies to both, but it only applies to the extent that you are caring for your kids.
How are employees' health benefits paid while they are out?
Say again?
How are employees' health benefits paid while they are out?
Under the FMLA, you're actually able to charge them. Part of the tax parts that are built into the law is allowing you to use payment of those benefits expenditures as part of the things you could claim the tax credits for, or to use if you got the payroll protection loans. There's a whole lot more detail to build into that, but they are potentially paid by you, but potentially offset by credits and or forgivable loans from the federal government.
And to piggyback that as well too, again, as an example, what we've done with staff members here who have gone out on medical leave previously. In the conversation, we talk about what the medical costs are, what the premiums are, whether it's for them as an individual or as a family. And I give them a sense as to what that total cost is going to be upon their return. And I've worked with different employers where I've either had them pay me that back in one installment, or they've continued to pay me that along the way individually, or I've worked out a payment plan through, say, over a period of 90 days of additional catch-up payroll deductions.
If we determine that we are exempt from paying leave to our employees, what else are they eligible for? Is unemployment a good resource?
So if they are working, they're just working. If you determine that you are exempt from paying the child care part, and they can't, they have to be home, then that could be considered as a basis for unemployment, and they could collect under those bases. We didn't go into it in a great amount of detail here, but there are all sorts of new mechanisms or new reasons that you can qualify for unemployment compensation, and among those are having to care for your kids in the context. So it's a potential resource for it. I would not encourage you to try and go into the nitty-gritty details as to whether someone is specifically available for one particular type of unemployment or not, or what the actual final number would be, because that's not a determination that belongs to you. But if they're unable to work and it is COVID-19, including school closure related, they may very well qualify for unemployment compensation.
And that's a common question I've heard as well too. I mean, federal law at the moment is, permits the state to make that determining factor about whether not working is related to, again, the schools being closed, or that they might be in a at-risk population that could be particularly susceptible to COVID-19. So that whole reasonableness and the validation process, again, to be clear, that determination is not by the employer, but is left at the state level.
If the employee utilizes the FFCRA, do we still withhold all of their deductions, example, health, dental, 401k?
Yes. I mean, to the extent that they're getting paid for, they are getting paid for, so you would still take the deductions for what they're supposed to be compensated.
If I have under 50 employees and am not required to provide the FMLA and other leave, if I opt to do so, will I be eligible to receive the payroll credits?
So just so that we're clear, and I saw a couple other questions to the same effect. If you are under 50 employees, you are still, there is no exemption from paying the time for paid sick leave for the individual caring for themselves. There is no opting out of that one way or the other. If you are under 50 employees and you determine that you are going to pay it out, then you are fully able to take advantage of any of the credits that are available under the law. The only thing the exemption applies to is the caring for the kids portion, which is functionally not an individual illness, but instead what I'll call a stay-at-home inconvenience, for better or for worse.
We got one question. What was the error on the risk assessment poster to look for?
Functionally, what they kind of messed up was the cap. It wasn't so much that they made an error as much as they made an assumption that then caused people to question the arithmetic. When you compare the paid sick leave with the family and medical leave for coronavirus, if you add up the paid portions, it comes to a total benefit of $12,000. But they had listed 10, in part because they were making an assumption. So if you think about it, you've got one bank of 2 weeks, which is the 80 hours of the 2 weeks of paid sick leave, and you also have 12 weeks of family and medical leave to care for the kid, for example. But only 10 of those are paid. So the Department of Labor in their posting jammed the two things together, and in doing so forgot to add the 2,000 to the 10,000.
We got one on the PPP. So under the PPP, what is the difference between the employer keeping an employee on payroll versus putting them on unemployment? If they go on unemployment, they can qualify for an extra $600 a week. But if we keep them on, they can just get regular pay, but I cannot get the loan forgiven.
Yeah, the way that they overlay with each other is non-optimal. It seems to me in looking at it that there are some significant upsides to employees in getting unemployment. Not that anybody wants to be on unemployment, but with the $600 bumps, and I saw a similar question to this, there's potential for what I will loosely call a windfall based upon what's here. It's built in some respects with the stimulus package and people getting checks cut to them. But you want to look at all the things together because there are limits that fall underneath the payroll protection law in terms of a reduction in forgiveness or otherwise if you let people go. So on some level, you may very well want to look in terms of any staffing or layoff decisions you're going to make prior to making the application for a loan, as opposed to making layoffs after you have the loan. But obviously those are details you want to work through not only with your counsel, but certainly with your accountants who are helping you look at your finances and decide what the best options are.
So we have one, we are lucky to still be working at full capacity. I'm concerned that the loans and emergency grants might be exhausted if we need them in the future. Can you apply and not use until it is needed? It seems too good to be true that these loans are fully forgivable. Can you tell us a little bit more about the strings attached?
I agree with the questioner. I'm always a little bit leery of strings that are attached. There are lots of strings attached in terms of promises you have to make to keep people employed, promises that you won't outsource work, neutrality for unions. They're pumping astonishing amounts of money into this. Exactly where that extra cash is coming from is not entirely clear to me, because this is just taxpayer money. So the money that your company pays in, the money that you pay in individually, is the U.S. Treasury, and that's where this cash is coming from. It is my understanding that in applying for the loans, it is tied almost directly to what your payroll and other expenses are. So I think on a certain level, the expectation is that you would have it to be able to make those costs. I'm not the person adjudicating whether the loans are listed, though I suspect if you work with your banker, you can go through it. And frankly, there are, I think, other presentations even put on even by my firm in terms of a deeper dive on some of these loans. I will fully agree that the idea of free money is going to make me leery, but at least my understanding is the whole goal is to help the company and especially small businesses crest through this incredibly unprecedented period of sort of a virus. It's one thing if you're waiting for snow to melt or floodwaters to recede, but here you're fighting something that you can't necessarily see. So there are some truly extraordinary pieces of relief, including forgivable loans.
What kind of documentation can my company request so to prevent employees from abusing the leave?
I mean, to the extent that we're talking about family and medical leave, you probably know if their school is or isn't open. To the extent that we're talking about an individualized medical illness, I have no problem with you using the plain old FMLA forms because they ask for a doctor's certification. And you should be able to get whether that is the straight up doctor's certification, because like from an office visit, or if it's telemedicine or printout from it and sort of them directing them to be self-quarantined or otherwise. The FMLA, which they've now grafted these things into, has certification requirements that are built into it, so you can actually leverage those to get the information that you want.
What is the technical difference between furlough and layoff for the purpose of these programs?
I mean, there isn't one for the purpose of these programs. I say that from the standpoint of unemployment, all those sorts of things are available based upon a change to your working environment, meaning if you used to work 40 hours a week and now you work 5, you can actually get unemployment for the other 35 hours, at least in theory. Whereas a layoff is that your employment has ended. You may be called back again at some point in the future, but a layoff tends to be, I'm ending your employment and hopefully if business picks back up, I'm going to bring you back. Whereas a furlough is the person is still on your books, but there's just no work for them to perform. It may very well be based upon your benefits programs that people can maintain their benefits while on furlough, whereas they would be straight on to COBRA if we were in a layoff situation, but you'd have to look at your actual plan documents to answer that question.
I'm seeing we're almost out of time. I think one question that would be useful, there are a couple questions about resources that employers should be looking at on a regular basis in the future. Can you just speak to a couple of your recommendations?
Sure. I mean, I will say that Jackson Lewis, since we're tracking so many things in so many different places, we've actually come up with, it's 7 different live spreadsheets. And I say live, meaning you can click into them. They're being updated based upon new orders that we get from various places across the country, whether it be states or otherwise. The Department of Labor is regularly putting out questions and answers, and hopefully soon they'll put out regulations. I saw a couple questions in there going towards webinars. There are lots of folks offering information up in terms of trying to interpret these things, which are coming out faster than water from a fire hose. So what I'll do is I'll convert over these slides into a PDF so they can be shared, and I'll include in that email when I send it on into TCIA to be shared with you all some links to those spreadsheets that I was referencing. And if you go to, because I saw a couple questions to this effect, if you go to the jacksonlewis.com website, you can sign up for those briefings, including the OSHA one that's supposed to happen tomorrow. And I believe there are some other ones coming up on the loan applications under the CARES Act. I know there are some aspects being covered about unemployment, but unemployment's a little bit trickier, obviously, because it very much matters as to how your local area, meaning especially the state, is handling unemployment claims in these extraordinary circumstances.
And one of the websites I've been frequenting almost daily is the Department of Labor's Families First Response Act for their Q&A webpage. Since the page has been initiated, it's gone from about 30 FAQs to, at this point in time, about 59. So that is one page I'm constantly checking almost daily, and we do have that linked up on the TCIA Company Resource tab.
Well, this might be a good place to end things. I want to thank everyone for participating in the webinar. As Matt said, we will have the presentation recording available later today on tcia.org and also Matt's PowerPoint available. We'll continue to check on the COVID-19 page on tcia.org for updates, or call us, and stay safe, everybody.
Thanks, everybody.
Well.